This is part 7 of contracts, looking at conditions and performance. A condition is a future and or uncertain event that must take place before rights and or obligations are created, destroyed, and or enlarged. Conditions may be waived by a party whose duty is subject to the condition. If I say you have to paint my house before or by, starting in May, you have to paint my house. Maybe you want to start in April. That's fine. You can do that. An express condition is expressed in the contract, quote, on the condition that, quote, provided that, and this must be complied with fully. Implied conditions are suggested by the nature of the agreement, most common in construction and or employment contracts. Builder and an employee must at least substantially perform before payment comes due. Disputes about performance and recovery is where the express condition of full performance must be completed first, or implied and or constructive conditions, substantial performance is okay. Disputes about performance and strict performance under the UCC. UCC requires perfect tender as a transfer of ownership of conforming goods. Substantial performance applies only in installment contracts or when agreed to by the parties. Looking at the method of tendering the goods under strict performance under the UCC, it's a shipment contract. The seller delivers goods to the carrier, makes a contract for their shipment, obtain shipment paperwork, and delivers to the buyer, and gives the buyer notice of the shipment. A destination contract, so that was a shipment contract. A destination contract, the seller must deliver goods to a particular place and tender them there. Buyer's obligations in regards to strict performance under the UCC and the duties, disputes about performance. Buyer has an obligation to accept and pay when conforming tender is made. Now, a buyer's right to inspect. They have a right to inspect unless the contract stipulates otherwise. They have a right to inspect as a condition of payment. Divisible or installment contracts and disputes about performance. Under the common law, units of performance divisible into distinct parts. Recovery only for segment performed. Damages for remainder unperformed. Under the UCC, perfect tender rule does not apply to divisible or installment contracts. The right to reject is based on substantial conformity, or a buyer can reject if substantially impairs value or cannot be cured, or the defect cannot be cured. Moving on to breach and remedies. Under the common law, when there's a material breach, you can withhold performance and pursue remedies and or damages. A material breach is where the non-breaching party does not receive the substantial benefit of its bargain. Where it's a minor breach, meaning substantial performance, the non-breaching party may pursue remedies for non-material breach. Now, if a minor breach is in connection with anticipatory repudiation, this is treated as a material breach. The non-breaching party may treat that as a material breach. Under the UCC, strict performance is required, and material breach applies only to installment contracts. Breach with anticipatory repudiation under common law, anticipatory repudiation only applies in bilateral contexts. The repudiations were the promisor refusal to fulfill an agreement and or obligation. This must be clear, maybe by acts and or words. The promisee may treat as a breach or ignore and demand performance. If ignored, promisee must suspend performance to limit damages to the promisor. You may retract repudiation unless promisee acts in reliance on, accepts repudiation, or commences action for breach. Anticipatory repudiation and breach under the UCC is an unequivocal refusal to perform or reasonable grounds for insecurity, must provide assurances within 30 days of demand for assurances. If demand is made, performance is suspended until assurances received. Remedies for breach and expectation damages. This is to put the injured party in the same position as if the contract had been performed. Example is B breaches a contract to fix A's car for $500. A gets C to fix car for $700. This is the market value of performance. A can recover $200 from B. In a construction contract, it's the difference between the contract and the cost from another builder. Generally, it's the difference between the value received and the total value. Now, if I was to get $100 and only got $50 because of your breach, you owe me $50. Now, remedies for breach and consequential damages and foreseeability, these go beyond expectation damages. And again, expectation damages are to put the party in the same position as if a contract had been performed. So consequential damages go beyond that. These are for loss of profits. It must be natural and probable consequence of the breach. Remedies and incidental damages. These are commercially reasonable expenses in regards to goods. This is inspection, transportation, caring for, maintaining custody over those goods. And that concludes part 7 of contracts.